Attorney General in the Consumer Protection Division of the Nebraska Attorney General's Office. He focuses primarily on matters involving nonprofit corporations, charitable trusts, endowment funds, and consumer protection issues. His law degree is from the University of Nebraska. So, Daniel?
Good afternoon. Thank you to the bar for having me and for providing caffeine for my after lunch presentation. I promise to make it hopefully relatively enjoyable, but I also am a government attorney, so I've never been accused of being particularly funny. The top reasons why nonprofits get investigated. The usual disclaimer is here because I went to law school and that's one of my worst personality traits. I would also say if any of your clients or if it seems like I'm talking about any of your clients, I promise I'm not. We're talking in purely hypotheticals here. And also look to tax lawyers or actual lawyers instead of just doing what I say. So the kind of guide star, the lodestar of my presentation is in this quote from the Nebraska Supreme Court. The privileges provided by law to public benefit corporations and other charitable institutions carry a corresponding obligation to be accountable to the public for the actions such institutions undertake. So what that means is that the Attorney General has the right and the duty to act in the public good in enforcing the requirements applicable to nonprofit corporations, and we'll also talk about charitable trusts and endowment funds, but in particular in the case of public benefit corporations. So you heard earlier today where there are three types of nonprofit corporations in Nebraska. The Attorney General's office has some jurisdiction over all types of nonprofit corporations, but our primary focus is on public benefit corporations. So in other words, as the Supreme Court says, the Attorney General has standing to protect the public interest. So what does that mean as far as what our office does and what our mission is? Well, a couple of things. So the first thing is that we believe an efficient and successful nonprofit sector is absolutely essential to Nebraska's well-being. Nonprofits employ approximately 10% of Nebraskans, and so supporting that sector and that industry is good economic sense for the state, but also just the things that the nonprofit sector can provide to citizens of Nebraska and to the public that government either can't or won't. All of those things are benefits that we see and that we want to help support. So what we do we believe supports that goal. So there are 1.5 million 501c3s in the United States. Almost 10,000 of them are in Nebraska. So, you know, we understand that it's a difficult world out there for nonprofits and that there's a lot of competition between nonprofit for donors' dollar. And so what our office aims to do is to, number one, get rid of bad nonprofits that can take donors' dollars away from legitimate organizations. And number two, make sure that legitimate organizations are operating in such a way that they are really truly serving the public. So the other things, we believe the nonprofit sector represents some of the best people and ideas in Nebraska, as evidenced in this room. And the Nebraska nonprofits do an incredible job. So kudos to you all or to your clients. It doesn't get said enough. So we've talked a little bit about how the Internal Revenue Service and the Secretary of State deal with nonprofits. I'll focus mainly on the Attorney General's office's role in regulating and enforcing the laws around nonprofits. But these are kind of the three main institutions or organizations that a nonprofit should have to deal with. So what I'm going to do is go through the top 10 ways to get investigated. I talked a little bit, or I mentioned that there's in statute sort of a regulatory angle that our office has. So you'll see our office needs to get notice when certain things happen in a nonprofit's life cycle. And then we also have a sort of a law enforcement angle. So we can, do a lot of things like remove trustees or put nonprofits into a receivership. So there's kind of two different ways that we can look at our office's role. If you watch Homeland at all, you'll know that what our office does is the exact opposite of that. So it's not that exciting. I will not be on an HBO show anytime soon. Okay, so the top couple of the top ways that nonprofits can get investigated by our office. Number one is the big one: failure to follow mission or being asleep at the wheel. So directors have a duty to actively work towards fulfilling mission, and nonprofits generally have this duty. So can you say what your organization does? This is, the elevator pitch, right? If you can't pitch to me on an elevator what exactly it is your organization does, it's a good indication to me that either one, you don't really know, or two, you've taken on too many responsibilities and you might not, you might not have the focus that's required to really serve the public in the way that you should be serving the public. So this also means nonprofits should have tangible critical assessments of efficiency and program success. So bad excuse number one is, well, technically it's legal. And that's true. As Professor Stowe's talked about earlier this morning, a lot of articles of incorporation give nonprofits broad legal authority to act. And that's perfectly fine. A lot of nonprofit or articles of incorporation just want to use the word eleemosynary, but that doesn't mean that you can kind of just do whatever you want. What will your donors say? What will your constituents say? Just because your articles allow you to do a certain thing doesn't mean that you should necessarily undertake it. The number two way to get investigated by our office is conflicts of interest. We've already talked a little bit about conflicts. In particular here, we're looking at conflicts as defined by the Nebraska Nonprofit Corporation Act. So just generally, a nonprofit corporation should be above reproach. We like to talk about nonprofits should be operated with glass pockets. If any transaction gives even the appearance of a conflict of interest, think hard about whether or not your organization should be engaging in it. So would the media and would your mom understand? And remember, the IRS, your donors, the media, the general public, they all have different views of conflicts of interest. None of them are particularly good. So when we look at what a conflict of interest is defined as under the Nonprofit Corporation Act, it's a transaction with the corporation in which a director of the corporation has a direct or indirect interest. The second bullet point, though, is the more important one for what my office does and what I do. A conflict of interest transaction is not voidable or the basis for imposing liability on a director if the transaction was, and underline here, fair at the time it was entered into or approved by certain parties. So what our office does, if we get complaints that a nonprofit has engaged in conflict of interest transactions, generally what we're looking for is whether or not those transactions were fair at the time they were entered into. Whether or not they were fair at the time they were entered into might be a different question than whether or not it's a good idea for the nonprofit to engage in those conflict of interest transactions. Because again, there are different people besides regulators and law enforcement who are looking at these conflict of interest transactions when they decide to investigate or look into your corporation. So there are a couple of other different ways that conflicts of interest transactions can be approved. Either before or after the transaction, if it's approved by the Attorney General or District Court. My experience is that this is more of a ask forgiveness, not permission kind of situation for most nonprofits. So a lot of people, not many people, no people have ever come to me and asked whether or not a conflict of interest transaction is approved beforehand. But that is a way to do it, so feel free to call me up. And then a conflict may be approved by the board of directors or committee under certain circumstances. And I would suggest that you read the statute there. Number three big way to get investigated by our office is fraud, embezzlement, failing to respond and prevent. So obviously nonprofit corporations and their directors have fiduciary duties to protect their assets. This was, really succinctly summarized by Professor Stowe earlier when he talked about nonprofit corporation assets are really public assets. So the public in general, and the public is really my client, the public in general are who should be benefited from those assets. So obviously fraud and embezzlement is really stealing from the public. So it's important because they're stealing from you. 1/6 of major embezzlements occur at nonprofit and religious organizations, second only to the financial industry, and many, many organizations are victims and don't know it. So what should your organization do to try and prevent fraud and embezzlement? Well, first of all, take reasonable steps, right? Just as a director, you have a duty of care and loyalty to the organization that should push you in these directions. But what steps you take will depend on your organizational size. Even the smallest organizations need to take steps. So if that means having dual signatory power on checks, or something like that, having multiple people access the bank account, even if you're only like a 3-director organization, you can be sophisticated about how people interact with your assets and that sort of thing. Number 2 is there really is no substitute for constant vigilance. Culture and small steps go a long way. So what we have talked about in this presentation before, or what was mentioned in the presentation before, is reporting hotlines for whistleblowers. So confidential hotlines for people to get in contact with someone, usually with someone who isn't the executive director, to report things that they see amiss. Generally, when we are told of situations where fraud or embezzlement has occurred at a nonprofit organization, we start poking around and asking people below the director level, kind of line members of the organization. Everyone seems to say, oh yeah, I knew that, the ED was spending too much on travel, or, he was taking people out to dinner, or she was, buying stuff on the company credit card. So people generally know, they just don't want to report it. So having some type of whistleblower hotline, even an email address that you can send anonymous emails to, or sourced emails to, is important, because we want people to be able to interact with the nonprofit and provide this vigilance for the nonprofit. And then finally, remember that audits are generally not designed to catch fraud. They only test the accuracy of internal financial statements. So when we get to our bad excuses, bad excuse 2B is we thought our auditor would catch that. The auditor is generally not there to catch fraud and embezzlement. The auditor is there to check internal financial statements against each other. So backing up just one slide, fraud and embezzlement will probably happen to an organization here or to one of your clients. Make sure that you're taking reasonable steps in response to that fraud and embezzlement. So punish the offender. We see too many organizations that say, well, this person is crucial, so we'll have them pay back what they stole, but we can't get rid of them. No, they have stolen from you. They shouldn't be around anymore. Report to law enforcement. That's kind of self-serving, but I think you should do it anyway, because it will always be better for an organization if you are upfront with law enforcement and if you cooperate, and then try and get your money back. Do what you can as an organization to get your money back. And then finally, and this is the part that our office, or the Attorney General's office, most wants to emphasize, because it's the part that we can help you with, is to close whatever loophole was exploited. So this is an opportunity to strengthen your organization. I can never remember a situation where someone has come to us and said, we think our executive director, we think a board member is embezzling money or taking money from us, and we didn't use it as a time to strengthen the organization as opposed to close the organization. So a lot of people say, well, if we report this, then the AG's office will shut us down. And that's really only in the most systemic, worst cases. Generally, what we want to do is work with the remaining members of the board, or the remaining officers, to make sure that this stuff can't happen again. So our bad excuses here, we completely trusted whoever. That's fine, but it doesn't mitigate your responsibilities to make sure that you're taking proper steps to prevent fraud and embezzlement. We didn't want our donations to suffer, so we didn't tell anyone. Okay, but the truth will out eventually, and it's a lot better to get ahead of this as opposed to reading it in the paper kind of by surprise. And again, our office is more than willing to work with organizations to say, this happened. We acknowledge that it happened, but we've taken these steps with the Attorney General's office to make sure it won't happen again. And then bad excuse 2B, we thought our auditor would catch it. Auditor's not going to do that for you. Number 4 way to get investigated by our office is paying excess compensation. So all of your assets must go to charitable purposes. You must pay reasonable compensation here. So reasonable is really the key word on this slide. Everything should be reasonable and justified. Avoid paying substantially more than similar organizations, and avoid having lavish expense accounts. Most nonprofits don't have expense accounts anymore, but we do see nonprofits that give their officers or certain directors access to credit cards. So what I would remind this room is 21-1988 specifically says that nonprofit corporations may not lend money or guarantee the obligations of a director or officer. So that means that if you have an officer and the officer says, well, I need a loan from the nonprofit, if that, I understand kind of the social pressure to say, well, this officer, this director has been good to us, we can afford to give them a loan, but it's specifically prohibited by state law to give loans to officers and directors. Some of the other things that we think about when we think about excess compensation are the IRS private inurement rules. So is the assets of this organization inuring to the benefit of private individuals? So one of the big things that we talk about here is bonuses. Whether or not nonprofits should even give bonuses is, I think, up for debate. In my mind, you work for a nonprofit organization because, well, for a lot of reasons. You don't have to work for a nonprofit organization and be poor, but at the same time, there is a trade-off. When you work for a nonprofit organization, hopefully you're supporting and furthering a mission that you agree with. So there are, certain compensatory trade-offs there. Bonuses certainly fall into that. You should be working hard to further the mission of the nonprofit, whether or not you're getting a bonus. There shouldn't be extra money lying around at the end of the year for a nonprofit organization. So in my mind, bonuses are a particularly tricky area. I was talking to an executive director a couple of weeks ago about this bonus issue, and he said, well, you work for a law firm, don't you get a bonus at the end of the year? And I said, I work for the government. That's not how this works. So bad excuse number 3 is we had leftover money. So we figured we'd go to Vegas, buy a BMW. This is a bad excuse for 2 reasons. The first, obviously having leftover money at the end of the year is not really a thing that can happen in nonprofits. You don't have leftover money. You have money you didn't expect that you can put to your mission. And then number 2, it's a bad excuse because it's really boring, right? If you're going to embezzle or whatever, don't just go to Vegas, go to Amsterdam, don't buy a BMW, buy a blimp or something cool. That'll make my job a lot easier or a lot more fun maybe. Okay, number 5, failing to operate with the needed transparency. So this is one of our top complaint generators, but it's also an easy follow-up for us. The law in Nebraska lists required corporate records that a nonprofit organization must have and gives inspection rights for members of the organization. So this is another thing to consider when you're considering whether or not a nonprofit organization should have formal members, is your members then have inspection rights under Nebraska statutes. So the law is that directors should have access to all of the nonprofits' books. If you are a director, it's hard for me to imagine that you're fulfilling your duties of loyalty and care if you don't have access, if you're not looking at especially financial statements. So the bad excuse number 4, only our treasurer gets to see our financial records. I think we can see why that's a bad excuse for a couple of different reasons. Well, first of all, no one person should ever have access to especially financial records. And number 2, as a director, you shouldn't have to rely on your treasurer to tell you a summary of what your financial records are. You should have access to your financial records so that you can check it out yourself. Number 6 is directors and officer and senior leadership failing to be sufficiently active. So as you can kind of see, a lot of these blend together. If directors and officers and senior leadership aren't being sufficiently active, it's likely that the nonprofit isn't operating with the needed transparency, and also likely that we are maybe a little asleep at the wheel and we have uninterested directors. So, or excuse me, not uninterested, that's a legal term of art, but unengaged directors. So directors have a fiduciary duty to be active and obtain sufficient information to make informed decisions. Directors need to understand the organization's financial health especially, but also programmatic health, so making sure that organizations are on the right track as far as the programs they're offering in terms of their mission and in terms of those programs actually accomplishing some goal. And there needs to be regular reporting to the board. So hopefully this is occurring at a very regular board meeting that's happening and not just, once a year or whatever. But the directors should know all of the nonprofit's activities. The directors should actively seek the information they need. And this is a big one that we run into, especially with smaller nonprofits. It's important for board members to remember that the executive director works for the board. So I think that last bullet kind of carries a couple of implications. So the first is we see problems with executive directors who kind of manhandle their boards, who are the ones that can, tell the boards this is what we should be doing, who are essentially the ultimate decision makers at the nonprofit. But that is not how the statutes are set up, and that's certainly not how liability is assigned under the statutes. So liability, as the statutes are written now, flow directly through the board members and through the directors. So as a director, just kind of for your own sake, I think it makes sense to remember that your ED, your officers, and your executive director work for you. So you need to be doing the work, not just relying on your executive director. But also, I would strongly recommend that any board or any nonprofit in here, when you have your board meetings, that there be a certain portion of that board meeting where only the board is meeting, where the executive director and any other non-essential staff are kind of booted out of the room and the board can just talk just between the board. So instead of, having the executive director always being there and kind of guiding meetings, kind of putting on a show for the board, we want the board to be engaging in these discussions and in these decisions very seriously. So bad excuse number 5, which we sort of already covered earlier today, is we're a volunteer board. We don't have the time to do this, that, or the other. Despite the fact that being a volunteer board does offer some protection, as was discussed, as far as liability is concerned, it doesn't mitigate or it doesn't abdicate some of the responsibilities that directors have under the nonprofit statute to fulfill their duties, especially the duties of loyalty and care. Okay, number 7. A good way to get investigated is not filing what you should with government agencies. So as we, again, have already talked about, a nonprofit should be filing some type of 990 every year, whether it's the Form 990, the 990-PF, 990-N, or the EZ. There should be some type of filing that's occurring with the IRS every year. There is an automatic loss of exemption if you don't file something for three consecutive years. But there are also filing requirements for nonprofits with the Secretary of State. So on odd-numbered years, nonprofits need to file their biennial report with the Secretary of State's office. This report is just it's just a list of your board members, where your registered agent is, what your name is, what type of corporation you are. It costs $23 to file. It's really not that big of a deal. It should take any well-informed board about 7 minutes to fill it out. But if you don't file it, you can lose your Nebraska nonprofit status. And the Secretary of State's office has gotten really good at, administratively dissolving nonprofit corporations that don't file their biennial report. So again, it's just one of the boxes that as a nonprofit board you need to tick off every other year. And then, of course, for any private foundations that are represented here, you send your 990-PF to the IRS and at the same time send a copy to the Attorney General's office, and then I get it in my mailbox. So make sure that you're sending us your 990-PF every year if you're a private foundation. That's an IRS requirement. So beyond just these, what I would describe as our more regulatory role in receiving those reports, the IRS's role in gathering those reports, or the Secretary of State's role in receiving those reports, there are also certain things that you should notify the Attorney General's office about when they occur within a nonprofit's life cycle. So the biggest one, and the one that I do most often, is dissolution and transfer of assets upon dissolution. So that you can see the statute there. What I would suggest is that you go to our website, which is linked at the bottom or at the end of my slide presentation. It's easy to remember, protectthegoodlife.nebraska.gov. If you click on the nonprofits section, we have a nice little form you can fill out if you're dissolving a nonprofit. So that will come to our office. It will give us notice, and also will allow you places to attach all of the things that we want when a nonprofit is dissolving. So our role in dissolution is to make sure that nonprofit assets are protected. And that's really, that's our role always, but especially in dissolution, is to make sure that nonprofit assets are protected and that they're going to another nonprofit organization. Another time when our office requires notice is nonprofits selling or transferring all or substantially all of their assets not within the regular course of business. So if most of your assets are, or if most of the nonprofit's assets are tied up in the building they own and you decide to sell the building, that's something that we want notice of, or we are required to receive notice of. Well, we'll analyze those transactions to make sure that they're fair, to make sure that there's no conflict of interest there. That sort of thing is why we want and why we receive notice when there's a sale of all or substantially all of a nonprofit's assets. And then finally, we receive notice when there's been a commencement of any proceeding that the Nonprofit Act authorizes the Attorney General to bring, but has been commenced by another person. So as we heard earlier, a lot of litigation against nonprofits is things that our office isn't necessarily involved with. Harassment and discrimination claims are not something that we'll intervene in. But if there are allegations that a director has violated his or her duty of loyalty or duty of care, then, first of all, we should be receiving notice that that complaint has been filed. And second, we would take a hard look to see whether or not there's a public interest that isn't being protected that our office should be involved in that litigation and should be protecting. So that's another example of when we should be receiving notice from you all. So why is it important to give our office notice and to give these agencies notice? We talked about the sanctions from the agency. No one likes to be administratively dissolved. At this point, it's not the end of the world if you haven't filed your biennial report, but it's a pain to have to reinstate with the Secretary of State's office. But the more important thing are these second two bullet points. So the public will misinterpret if you aren't filing, if you aren't giving notice. Donors, potential donors, clients, and everyone else will all see your lack of filing. So I get calls probably once a month from some person who wants to donate saying, well, I want to give I want to write a big check to this nonprofit, but their latest 990 isn't up yet. I'm going to GuideStar, I'm going to Charity Navigator, and I can't find their 990. And, that's hard for me because the Attorney General's office doesn't have a lot to do with public charities' 990s. But I can see and I can tell just by speaking to these people that they think something is fishy, right? It's not necessarily that that nonprofit is doing bad things. Maybe they just asked for an extension, but they will misinterpret if you aren't filing the correct things with these agencies. So remember that all of this information is just a click away. And along with that, pay attention to your nonprofit or your client's digital footprint. So you want to look at rating sites that rate nonprofit organizations. Give.org, Charity Navigator, GuideStar I think now offers ratings, the Better Business Bureau. And then you want to also make sure that your information has been uploaded to these 990 sites. Usually they just pull those straight from the IRS, but if some glitch has occurred and you're surfing on GuideStar or the National Center for Charitable Statistics and you see that your client's information isn't up there, then you can get in contact with them. I would strongly advise. What I would also say, just expanding on this a little bit, is that paying attention to your digital footprint doesn't just mean checking these sites. It also means, what pops up when I Google your nonprofit. Making sure that your Twitter name has been claimed, and Facebook and Snapchat or Instagram or whatever else the kids are on these days. But making sure that your nonprofit is accurately represented online is an important kind of new part of a director's duties. Okay. This is a little bit of a shift into some of the other areas of charitable giving that our office regulates or enforces that don't have to do necessarily with the Nonprofit Corporation Act. And those are the Uniform Trust Code and then Mytha, the Uniform Prudent Management of Institutional Funds Act. So either way, if you're a nonprofit, if you're a director, you should be aware of certainly an endowment fund, if there are endowment funds that your organization holds or is trustee to, but then also restricted assets, because sometimes you'll have donors who say, well, I want to give you money, but I only want to use for this particular thing. The wishes of that donor should almost always be granted. So both of these sections deal with restricted assets and endowment funds. So we'll talk a little bit quickly about charitable trusts and endowment funds. So charitable trusts can be created for a wide variety of reasons in Nebraska. The most important thing with regards to what our office does is that the definition of a charitable trust is very broad in Nebraska. So trust or a portion of a trust created for a charitable purpose. So generally what that means is that, or how we interpreted that, is that if there's a charitable beneficiary in your trust document, at least a portion of that trust is charitable. And that kicks in a whole bunch of other notice requirements that we'll talk about later. But notice here, recognize here that the definition of a charitable trust is very broad in Nebraska. Again, in the case of a charitable trust, the Attorney General has long been recognized as having the right to maintain an action for enforcement of the trust or to prevent a misuse of the property. So under statute, the Attorney General has the rights of a qualified beneficiary with regard to charitable trusts whose principal place of administration is in Nebraska. So what does that mean? There are notice requirements under certain circumstances, and the Attorney General has statutory authority to enforce the trust, bring a petition to remedy a breach of trust. So here are some of the notice provisions, and if you're a trustee or if you represent a trustee, I think it's just best to add our office to your list of beneficiaries to the trust, because we should essentially be getting all the communications that other beneficiaries are getting. So we need to be kept reasonably informed about the administration of the trust and of the material facts necessary for us to protect our interests. The interests that the Attorney General has are the interests of the public. So making sure that charitable organizations receive the money that then they can use to benefit the public. So this means a couple of different things under statute. It means that trustees should notify qualified beneficiaries in advance of any change in the method or rate of the trustee's compensation. And then also that qualified beneficiaries can request an annual trust report outlining, the assets, liabilities, disbursements, receipts, et cetera, of trusts in this state. So if you are a trustee, if you represent trustees, if you're listening at home and are either of those things, haha, I got you. I want your annual trust reports. Please give them to me. So if you are getting these, getting these annual trust reports, or you should be creating these annual trust reports for your beneficiaries anyway, make sure you're sending them to my office as well, because we're a qualified beneficiary under the statute. There are a couple of other things that you should be doing if you're a trustee: furnishing a copy of the trust instrument upon request. I also want one of those, please. And then telling the beneficiaries that you have accepted a trusteeship and giving us your contact information. So that doesn't happen very often. I want it to happen more. So if you are a trustee or represent trustees, please pay attention to this particular statute. Just let me know, drop me a line or shoot me an email, whichever is easiest. There are also notice provisions for when trusts need to change. So if trust administrative terms become impracticable, wasteful, or impair the trust administration, then as a trustee, you can get either the consent of all the beneficiaries or petition a court to change the terms of the trust. Same with cypre. So if the charitable purpose of the trust becomes impracticable, impossible, or wasteful to achieve, then we can change the terms of the trust, but that's something that you need to work with our office on. We want to receive notice, and then we will sign off or at least not object to any proposed changes in the trust. The big one here is termination of an uneconomic trust. So in Nebraska, an uneconomic trust is any trust that has less than $100,000 and in which the trustee decides cannot justify the costs of administration. If you are the trustee of a trust of less than $100,000, you might qualify to terminate that trust as uneconomic, in which case the assets of the trust would be distributed to the beneficiaries. And then also the combination and division of trusts would be another thing that our office should be notified of. So the main duties of the trustee, as we can see, aren't really that distinct from the duties of a nonprofit board member or director. If we're looking at it, I guess, from far enough away, you need to keep our office informed. So make sure that our office or the public, whoever's representing the public, is informed about what you're doing. Operate with transparency. There's a duty of good faith, duty to administer the trust, and a duty of loyalty. Administer the trust solely in the interests of the beneficiaries. There are also two others, duty of impartiality and prudent administration, that trustees need to follow. So as far as what our office can do when we see there are charitable trust assets being misused or misplaced, we can compel the trustee to perform his or her duties or their duties, enjoin the trustee from committing a breach of trust, compel the trustee to redress a breach of trust, reduce or deny compensation to a trustee, or the most serious, obviously, remedy is removal of a trustee. So that is, that's both the most serious and the most difficult for our office to do. But we do have the power to do it under certain circumstances when there's been a significant breach. Is the statutory language a significant breach of a trustee's duty to the trust? So that brings us to a Mytha, which is similar to the Uniform Trust Code, except applied to endowment funds. So you can read this all kind of at your leisure, or if you're having trouble sleeping tonight. But the general idea is that an institutional fund, as defined in the statute, is essentially an endowment fund, right? So generally, institutional funds are endowment funds. Basically, what this means is that the fund is not expendable, is not wholly expendable by the institution on a current basis. So usually endowment funds are just spending whatever they receive in interest that year. So these types of funds are similar to trust funds. face similar restrictions on their use and governance and similar notice provisions to our office because, again, these are generally funds that are used for charitable purposes. The important part here is the standard of conduct in managing and investing in institutional fund is important, especially if you are a manager of an institutional fund. But what I would say is that the second bullet point, the general economic conditions, possible effect of inflation or deflation, expected tax consequences. So these are all things that the Uniform Prudent Management of Institutional Funds Act, that of Mytha, asks managers and institutions to consider when they're managing a fund. So these are all laid out in the statute. What I would say, and what I think the takeaway here is that these are all also things you should be thinking about if you're the trustee of just a regular charitable trust, or if you're a director or board member of a nonprofit corporation, right? So you should always be thinking about, the tax consequences of your actions, what the general economic conditions are the resources of the institution. You can read it all on your own, but these are good ideas as far as how you should be involved in managing the assets of a nonprofit or of a charitable trust, just generally. So again, under Mytha, the release or modification of restrictions on management, investment, or purpose needs to be, our office needs to be notified, and those releases can occur when something becomes unlawful, impractical, impossible to achieve, or wasteful. So one of the just kind of as an example, one of the things that we saw a couple of years ago was a lot of endowment funds that required the institution to only invest in, say, T-bills or treasury bonds. That isn't very prudent because we need kind of a more diverse investment pool for these institutions. But to a person of a certain age, I think it made a lot of sense. When I am giving to a charity in my will, I'm going to require that they only invest in treasury bonds. Thinking has kind of changed, and so what we've seen is that it's not really unlawful. It's not really impractical or impossible to achieve, but it is wasteful to restrict investments to only this particular type of thing. We could return a higher yield on the investment if we diversified our assets a little bit more. And so, we have approved a lot of different releases or modifications to endowment funds, not a lot of, but some releases or modifications to endowment funds because of the impossible to achieve or wasteful standard that is set out in the statute. Okay, number 9. Converting from a nonprofit to a for-profit, right? So this is another one that I think seems fairly obvious when we think about it for more than half a second, because nonprofit assets are public goods, right? Because they should be going to benefit the public. Converting from a nonprofit to a for-profit is generally not allowed. However, there are certain circumstances in which conversion from a for-profit or a nonprofit to a for-profit can occur, and those occur in 21-19,118 and 19,119. So if you're interested in those, feel free to check that out. But it would be another, again, instance where our office would receive notice. What we have generally seen, and what I understand as the trend nationally, is that most conversions from nonprofit to for-profit occur in the hospital arena. So that's not something our office has done very often, but we see it every once in a while, and so it's good to bring it up. But yeah. Not particularly, but I can. Yeah, and so the opposite would also be true, although there would be a little or some fewer restrictions on converting from a for-profit into a nonprofit. There we would be looking to see whether or not the conversion has actually happened, right? So if there actually is a charitable purpose that's being fulfilled by this newly created nonprofit, whether or not it's really just kind of a tax avoidance thing to switch from a for-profit to a nonprofit. Yeah, nonprofits can buy for-profits. All of this will, and they can merge together. They can separate or dissolve. All of that is laid out in the statute, and would also be a fundamental change under the kind of life cycle analysis of a nonprofit generally. So again, nonprofits must notify the Attorney General of fundamental changes. The statute generally gives us 20 days to review those changes. Dissolution, when we're dissolving or when we see a nonprofit dissolving, we want to make sure that the assets go to other nonprofits. So this would be like kind of a de facto conversion from a nonprofit to a for-profit would be if you dissolve the corporation, but then don't give those assets to another nonprofit. Then we could see kind of a de facto, conversion from a nonprofit to a for-profit. We don't want that to happen. We want those assets to continue to be used for the charitable purpose that they were received for. Mergers and then sale of all or substantially all of the assets. Okay, so the big one, number 10, reason why you would be investigated by our office, and that is ignoring the Attorney General's office. I like to say I'm like the worst boyfriend ever. I just want your attention all the time. So please give it to me. But I suppose that also applies to the IRS and the Secretary of State's office. They don't like to be ignored. Just generally, the government doesn't like to be ignored. So ignoring us is a good way to get investigated. So here's my contact information. Feel free to give me a call. Probably take 4 or 5 calls a week from individuals who, just have a question about how the statute is read or how we would see things. I can answer a lot of those hypothetically, but not give you particular legal advice. But I'm more than happy to kind of chat through whatever it is your nonprofit is facing. And also, there are so many notice provisions, as we've seen in the last 45 minutes, that you might just be giving me notice and not even think about it. So you might be fulfilling your statutory duties. The other thing I would say is that this protectthegoodlife.nebraska.gov is the website for our general consumer protection and antitrust division. So this includes not only nonprofits, charitable trusts, but also, a whole host of other things. The most important one is consumer protection. So our office has a mediation division. So if you feel that you've been scammed or defrauded by a for-profit company, feel free to make a complaint to our mediation division. We'll mediate with the company for you. It's non-binding mediation, but we do provide that service for free. And I think last year we recovered something like $1 million for Nebraska consumers. So, when you get the letter from the Attorney General's office, usually people don't ignore it. It's a lot harder to ignore our office if the complaint's coming from us than if it's just you. So we do have a mediation division and a form that you can fill out on that website, not only to submit complaints to the mediation division, but also to submit nonprofit complaints, dissolutions, all sorts of notice for charitable trusts and institutional funds. So with that, I am done. Do we have any questions? Seeing none, I will yield. Thank you so much.
Great. Welcome back for the final 2 presentations of the day. First, we're going to have Krystal Siebrandt, who is a partner at HBE, a CPA firm in Lincoln. In addition to being a certified public accountant, she has certifications or designations as a certified fraud examiner and a chartered global management accountant. Her primary area of focus is on nonprofits. In addition, she leads her firm's outsourced accounting services department, where in her role she serves as the outsourced CFO for many nonprofit organizations. And for our purposes today, she has also served on the board of directors for several nonprofit organizations, including current service to Friendship Home and Seniors Foundation of Lincoln and Lancaster County. So welcome, Krystal.
Good afternoon, and thanks for having me here today. And it looks like, I'm sorry I couldn't join you for the morning sessions, but it looks like you've had a lot of legal and ethical discussions about board responsibilities. So hopefully you're looking forward to a little bit of a change of pace and talk a little bit about finances. Either that or it'd be a good time for your afternoon nap, maybe. But today I'm going to try to keep it real practical and hopefully useful in any service that you're doing to nonprofits from a financial perspective. So first I'm just going to hit a little bit on the big picture, and I'm sure you've already talked a little bit about that this morning with your fiduciary responsibilities, which involve financial oversight. Then talk a little bit about reading and understanding not-for-profit financial statements because they are pretty darn unique. And then as a practical piece, talk about my experience with user-friendly board financial reports. So maybe a suggestion you can bring to some of the boards you serve on. And then finally wrap up by talking about annual IRS requirements and some just IRS compliance type issues you might keep your eye out for as you serve on boards or as you think about the transactions your nonprofits are dealing with. So want this to be conversational, so if you have any questions as I'm going through the presentation, please raise your hand and we'll take those as we go. So for the big picture, just a question I have posed up here: what is a nonprofit organization's most important asset? And I'm sure everyone can answer that pretty easily, you know, just in the roles that you play, both professionally and as board members. But it's not the cash they have in the bank. It's not the investments that you're managing. It's the organization's reputation. And as you all know, you know, one little fraud hitting the newspaper can take years worth of trust from your donors and grantors and just, you know, really make it hard to gain that back. And I love Warren Buffett's quote here: it takes 20 years to build a reputation and 5 minutes to ruin it. If you think about that, you'll do things differently. And that's just a great quote to think about as you join a board and as you serve on a board and you sit in meetings and the financial reports come up and you kind of do the approve, yep, motion to approve, accept, and move on. So specifically in a financial perspective, your responsibility as a board member is to, last on the slide there, safeguard the organization's assets. So that's what we just talked about, all those things that help you build the reputation that you have. But more specifically, that involves setting financial goals for the organization, and that means you should be involved in the budget process. The budget is your goal for the year, for the coming year, or maybe you do a 2-year budget, so the coming 2 years. But that's the way that you can make sure that your goals as an organization translate into the financial numbers. And then after that, then you have to monitor your progress towards those goals. So that is done by reading the financial statements. We'll talk a little bit later about the importance of a budget versus actual report, and that's how you can monitor your performance against your goals. So this slide has some things on it. I'm going to flip actually to the next slide and just talk about the things that were on the previous slide. But this is, we're going to go through the key financial reports that a nonprofit often has and the unique aspects of those. So I get a lot of, or I talk to a lot of board members who say they're pretty financially savvy, that they've served on boards of for-profit entities or that they're bankers, that deal with financial numbers all the time. But I don't think a lot of people always realize that nonprofit financial reporting is a lot different than for-profit financial reporting. There are some nuances to the way things are recognized in the financial statements, as well as just how some things are labeled and what those mean. So I'm going to go through some of those. So first off, even just the way the statements are titled are different in the not-for-profit world than the for-profit world. And you might not always see this on internal financial statements, but if you have an audit, you'll see this type of wording used on these reports. So understanding it is important. And the first statement is the statement of financial position, and that's the same, the wording that you would use in a for-profit is the balance sheet. So it's the organization's assets, liabilities, and net assets, which is just another word for equity in the for-profit world. And it's a snapshot, so it's a point in time. So this one happens to be at December 31st, but some organizations will have that as of June 30th, whatever their fiscal year end is, or the period you're looking at the financial statements for. So just a snapshot of a point in time. One of the primary differences on the statement of financial position or the balance sheet from the for-profit, and often something that is very hard for people to get a grip on, is the net assets or the equity of the organization and how that's broke down. And so right now, currently, that's your net assets or your equity of the organization is broken into 3 categories. The first is unrestricted, and that is just basically any dollars that you have that you haven't yet spent that can be used at your discretion. The other categories are temporary restricted and permanently restricted, and those are dollars that you've received that have restrictions on them that are placed by the donor. So the first key distinction with that is it's not a board set aside. So if you have $100,000 in your bank account and your board decides to put $50,000 aside as a reserve, that's not a restriction, because a restriction is driven by a donor, not the board. So temporary restricted would mean that it is restricted for a certain purpose or a period of time. And so it goes into that bucket until you've spent it for that purpose or spent it in that period of time. And then permanently restricted is money that you've received that you have to hold in perpetuity. So a lot of times endowment gifts are given to nonprofit organizations, and the principal of that gift should be classified as permanently restricted. So it's important to make sure your nonprofit organizations are really tracking restrictions, because again, those are donor intents, and if you get in trouble for not fulfilling a donor intent, that again goes back to your reputation and losing trust of those donors and funders that make your mission possible. Accrued expense is usually something that you, usually like let's take for instance, if you have a staff and you, their vacation is accrued over time, they haven't used it yet. So that would go into that category. Some of your payroll liabilities might also be classified in there. Any other questions on the statement of financial position? As a board member, if you're receiving one of these statements and you're looking at it, the things you should look for are trends. So comparing year over year, what's happened. Has our cash gone up? Has it gone down? Is property and equipment way up? Are we buying a lot of fixed assets? All those comparisons from year to year. And then also an important thing to look at is the organization's liquidity. So which of our assets are liquid, readily available for our use? And this is going to get even more important in the coming years, starting in calendar year 2018 and fiscal year, if you're on a fiscal year 2019. In the audited financial statements or reviewed financial statements, if your organization has an audit or review, you'll actually have to lay out quantitatively what your liquid assets are, and then also qualitatively describe how you see those liquid assets. If you have a goal for where you want to be with liquid assets, what do you do if you don't have a lot of liquid assets in case of emergency need of funds? So I think that's going to take a lot of thought by board members as well as management of nonprofit organizations because, like I said, some nonprofits will have a hard time telling their story as to why they're not liquid. They may want to try to secure a line of credit with a bank so that they have that as a fallback to describe in the notes to their financial statements about how they would gain some liquidity if they had a funding gap or if there was some economic crisis like in 2008, 2009. But on the other end of the spectrum, some nonprofits will have a hard time showing a lot of liquidity and saying why they think that's reasonable, and what their purpose for holding those funds is. It's effective for calendar year 2018 or fiscal year 2019, so coming up. And so we have a lot of organizations right now that are talking about what is the right number of months expenses to have on hand in liquid cash. And I think what we're seeing is a lot of organizations shooting between 3 and 9 months worth of budgeted expenditures. That would be probably a liquid item, but in that narrative, you'd probably refer to your reserve funds and how you hold them, how you manage them, what they're for. As far as the net asset section, if it's a board reserve, so the board's decided to set that aside, it goes under unrestricted, and then you can mark it as unrestricted designated. So the board has designated it for that use, but the board could take a new vote and unrestrict those at any time. So it goes in that unrestricted category. Depending on, how you hold it, some organizations will put their reserve funds in investments, which depending on how readily available the investments are, could be in current assets or long-term assets. The other thing you want to keep an eye on your statement of financial position is debt, especially if you have a line of credit, that you're not tapping into that too much without a plan to get it repaid. And then finally, the net asset section. Often see organizations that are tight on funding, their unrestricted net assets will go to negative sometimes, which means they're borrowing from their donor restricted dollars, which is always kind of scary. Again, want to make sure they have a plan for that. The next statement to talk about is a statement of activities, or in the for-profit world, you'd refer to this as the income statement. And this statement shows the result of operations over a period of time. So it could be the 6 months ended June 30, it could be the whole calendar year. But again, this is, the results of your revenue inflows and your expense outflows. Nonprofits, I think, get complicated because they can just have a lot of sources of revenues. Usually a for-profit has the thing or the few things that they do, and a nonprofit can really have a lot of sources of income. Can be from grants, donor contributions, in-kind gifts, program fees for the services they're performing, interest income, investment income, all of those things. And then one of the hard concepts for a lot of nonprofits to deal with is if they're using the accrual basis of accounting and they're working with contributors, donors, and a donor makes a pledge. So say I made a $10,000 pledge for 5 years. That all gets recognized in income in the year it's pledged. So it goes into the income statement in the year I make the pledge versus recording it in each of the years that I'll actually pay it to the organization. So that can make reading the statement of activities difficult for board members to see kind of where they're at when they are recognizing income that they can't even use, or the money's not even in the door yet. So just something to keep in mind there. When looking at the statement of activities, things to keep in mind are really, this one up here has just a year-over-year comparison. I would encourage you, like I mentioned earlier, to also have a revenue expense versus budget comparison, which again goes back to what are your goals and where are you at with them. And then, have explanations for why you're not meeting those, why you're exceeding those, so you can know that you're on track. Another really important thing to take a look at is just your dependence on major donors or revenue sources. So look at where your revenue is coming from and see if there's a concentration there, and think about that from a risk standpoint. What could we do to diversify our revenue sources more? What are we going to do if there's a funding gap from our major funding source? All of those questions. And then probably the most important thing to look at is the line that says increase in net assets. In a for-profit, that would say net income. So that's your bottom line. And always remember, and I'm sure you've heard this before, but not-for-profit is a type of entity, not a way of doing business. So you want positives there. Or eventually you're going to run into trouble and not be able to continue your mission. So, a lot of times in the past, prior to 2008 and 2009, you would see break-even budget and then really struggling to either break even during the year or have a small positive. But now you actually see organizations that are budgeting for a net positive and working towards those reserves we talked about. We're going to net $20,000 this year and put that aside for our operating reserve. And a lot more funders and donors are actually excited about that or positive towards that because they know that sustainability is important to carrying on the mission that they think is so important. Any questions about statement of activities? Yeah. Yeah, so that kind of goes into the tax issues and fulfilling your tax exempt status. So on the annual filing, the 990, there is a Schedule A, and it is your public support test. So you put on there the dollars that you've received from the public, and then you have to back out any large gifts. So you couldn't have $50,000 in total gifts and $200,000 of investment income for most public charities and have to back out that big gift and only be supported by your investment income once that's backed out. So it's kind of along the lines of that test, but you can still have some large ones as long as you have a fair amount of small ones as well. No issue other than if you're on the board, you should be talking about that because, if you rely on that for so many years and then all of a sudden it's gone, then you've got a big gap to make up to meet your operating budget. But other than that, no issues. Okay, the final statement that I'm going to talk about is a statement of cash flows. And this would be if you're using the accrual basis of accounting, again. And this statement takes the accrual basis financial statements and converts them back to cash. So how is our cash affected during the year? And this statement's broken into 3 sections: your cash flows from operations or operating activities, your cash flows from investing activities, and your cash flows from financing activities. And so what we tell our nonprofits is to really take a hard look at that first section, the net cash provided by operating activities, because that's the dollars that are coming in the door and going out the door for your mission. And again, not-for-profit is a type of entity, not a way of doing business, so you want to see that number positive, or at least know why it's not positive. If you've got some dollars that were pledged but not received, it might not show up in cash yet, but it's important to notice that. And then the investing and financing activities then are usually what you can do with your money that you're bringing in with operations if you're holding it. So, for instance, you could move some of your cash to an investment account. You could buy some property and equipment. And then financing activities are good to pay close attention to, because that means usually that you're borrowing money to carry out your mission. So things to look for there, again, just the total change in cash, which you'd also be able to see on the statement of financial position or the balance sheet. Cash flow from operations, like I said, is a big focal point. And then think about your cash reserves and your days operating cash on hand, because that is important to strive for goals there. And then as an auditor, I just wanted to say a few words about the audited financial statements. So it's important to have your auditors come present at the board meetings so you can hear firsthand from them what they think of how things are going with the organization. When you're looking at your audited financial statements, first and foremost, look at the auditor's report and the opinion in it. You want an unmodified opinion, so that's a clean audit opinion, and says that your financial statements are fairly stated in all material respects. So that's what you're looking for there. It's important to know that an audit is not guaranteed to catch fraud. Most of you, I'm sure, realize that, but is still, I think, a good practice for helping you with your oversight to feel more comfortable with where the organization is financially. And one of the really important things to remember is that you are, as management or part of the board of directors, you're responsible for the financial statements. So while there are certain things that have to go in the financial statements, the wording can be changed and modified so that it's pleasing to your reader, or communicates the story you really want to communicate. So keep that in mind as you're reviewing the financial statements, that if there's some wording in there that you just don't really like, or if the descriptions, headings aren't very clear, you have the ability to bring those things up and have them changed. Some things that I would encourage you to look at would be the footnotes to the financials. It's the pages that get kind of long but provide more detail. Just make sure you understand those, and again, that they're telling the story you'd want them to tell. And then also talk to your auditors about weaknesses in internal controls if they identified any, and if they had any management comments. Those are great ways to improve internal controls and operating efficiencies. Our firm works with over 200 nonprofits in a given year, so I feel like we just see a lot of things. So we try to, always add value in, what is something we've seen that might work well at your organization. So ask your auditors about those things if they have any recommendations there. Any questions about the financial statements? Yeah. Okay, so the question was, should finance committees and audit committees meet independently with the auditors from management? And I think it's a really great practice. Not all organizations do it, but I think the ones that are really fiscally responsible do. And I would say as an auditor, there shouldn't be anything that I'm going to tell you that I wouldn't bring up to management as well. But sometimes it gives the board members just a way to open some conversation on some other items that maybe they've seen throughout the year that they want to know if it came up during the audit or how it looked during the audit and things like that. So I think it's a great practice. Questions? Okay, so on a practical note, I wanted to not only just highlight the financial statements, but also talk about user-friendly board reports. And so I find that I get to go talk to a lot of boards, and there's maybe 2 or 3 people on the board that are really financially savvy, and then the rest of the board members are kind of like, we trust whatever they say. You know, they're the finance people. And I find that, that usually works pretty good, but what you'd really like to see is everybody using the financial statements on the board. And the way we've been most effective in being able to do this is through dashboard reporting. And so with the nonprofits we work with on dashboards, we really focus on what are the key indicators for your organization. That could be financial numbers. It could be number of people served. It could be a mix of both. Usually it's a mix of both. But it's a really eye-pleasing report that a lot of people can use. So we'll talk a little bit more about that. So what are dashboards? Just like the dashboard on your car, they're tools that help organize large amounts of data using performance indicators. So they summarize key financial and non-financial data. They help you set benchmarks for your organization, much like a budget, but a lot less numbers that are sometimes hard to read. And they allow users to quickly and efficiently view performance. So this is a great way to get the information out to people, but not spend a lot of time on it because it's so easy to read. So here, why use a dashboard? One, to minimize the time you spend on financial statements and metrics at board meetings. If you can look at the report and know exactly what you need to either talk about or what you're doing fine on, it's a great, just quick snapshot. You can communicate progress to management and staff members as well as evaluate them on the progress pretty easily and pretty clearly. And then it can be a great marketing tool. I've had a lot of organizations hand it to donors, hand it to grantors, or others they're just trying to teach about their organization. So internally it can be used by management, the board of directors, and staff. And then like I just said, externally it can be used by funders, lenders, and other stakeholders. So the hardest part about starting a dashboard report for your organization is identifying the information that really matters to you in a concise manner. And I've got a few examples of what it might look like, but it's going to vary from organization to organization. So if you've got a strategic plan for your nonprofit, oftentimes there's a lot of goals written into the strategic plan that then you could measure on the dashboard, so you're right in line with where you want to be. Also, if your organization has a lot of different programs, a lot of the program directors probably have goals as far as number of people served or dollars raised if it's the fundraising department or whatever. And then also there's a lot of industry benchmarks that you can use if you want to just make sure you're on track with where you should be for the industry. Or a lot of nonprofits have like a national organization, and so the national organization can give you benchmarking data for your area or for your type of organization. And some questions to think about as you try to identify what really matters for your organization is, how are you evaluated by others? What goals have you set your organization to achieve? So like your vision, your mission. And then what are the necessary program outcome levels and productivity? So what do you need to break even? What do you need to net that positive that will help you increase your reserve funds? And then as you visually put you format your dashboard, think about how it looks, because there's studies that show that people remember 10% of what they hear, but 80% of what they see. So you'll see as I show the examples, there's lots of color to them, and the colors have meaning and can really create that quick visual. So here is a sample dashboard report. This one I feel like has a little bit too much data on it, but again, it depends on the organization. But you'll see at the top it has a key right there that says red means we need to act now. So this organization, if they see something in red at the board meeting, they have to decide on an action. Yellow means we're going to monitor it, and then green means we're going to celebrate it. So we're doing well, and it's not something we have to discuss. On the next slide I have another one that's pretty similar, but I kind of like this one because it's broke up by different areas of the organization: finance, program, human resource, some even measurements that are specific to the board, like who's attending and how often. So that's great. Fundraising goals, and then compliance and risk management. But again, you'll see it uses the green, yellow, red coloring schemes to make it really easy to determine where you're at. And there are tons of these out there, so if you are thinking about doing something like this for your organization, Google dashboard reports or nonprofit dashboard reports. And then I gave you the source for this one as well. So any questions about dashboards or dashboard reporting? Just to kind of wrap that up, in summary, define what matters to your organization. Keep it simple. You know, we're trying to get away from reading 12 pages of financial data and just getting straight to the point and having people use it. Find a format that works for you, that your users like, and know what action will result from the data captured. So like we talked about, the red meant they had to act now. You should have some sort of expectation as to what you're going to do if the colors change or if your benchmarks aren't being met. Yeah, so the question was, what happened, or what are some examples of red flags that might show up on your dashboard other than kind of the obvious revenue isn't meeting budget type thing? I'm trying to think of a few that I've done. A red flag for me is often if the organization uses debt, you know, seeing that debt go up. A lot of the program numbers are actually really good signs as well. So if you wanted to serve 50 participants a month and you're serving 30, are you overstaffed? What other, you're not going to have the revenue that you thought you'd have. So what might be some of the adjustments you need to make? Are there fundraising efforts you could do to kind of bridge that gap type thing? Fundraising, it also works really well for fundraising because that's just really hard to budget, but you got to have some goals and you've got to kind of watch where you're at in relation to achieving those goals throughout the year. And I feel like if you are behind budget on fundraising, there's certain things you can do to kind of have board members act and staff members act and move that along, whereas if you just kind of wait till the end of the year to see what comes in, then you might not end where you want to end. And then, like I said, again, it's just a really great evaluation tool for staff members. So if they have specific goals that are on that dashboard and they know that you're monitoring them on a regular basis, it's really easy to have hard performance conversations if they need to be had, because it's been right in front of them all along. Okay, so that's all I had on financial reporting. I wanted to spend a little bit of time talking about the annual Form 990 IRS requirement or required filing. And I heard that there were a lot of questions on taxes from the earlier sessions, so if anybody has in those, I'll do my best to answer them. They're just a lot of unique things. So most of you probably know that all nonprofits have an annual reporting requirement to the IRS. Since they're tax exempt, it's not a tax return, but it's more, they call it an information return. And it's quite a lengthy return, I guess I'd say, depending on your revenue size. So organizations that are generally under $50,000 of gross revenues can file a 990N, which is just a postcard. It's an online postcard that goes to the IRS, basically updates the organization's address, says it's under $50,000 in gross income. It's a really easy process, but you want to make sure that you do that at least once every 3 years, or your tax exempt status will just be lost. And that happened to a lot of organizations when they first implemented this, and it's a little bit of a process to get that tax exempt status back. So you want to make sure you're in compliance with that, and I would just recommend filing it every year, no matter what, even if you're under the $50,000 threshold. Then up to $200,000, you can file the 990 Easy, which is an information return that's shorter in form. And then above $200,000, you have to file the full 990 with all the schedules. And so we all know that nonprofits generally do not pay taxes except on income that's unrelated to charitable purposes, and I'm going to talk a little bit about that later. But I find so many organizations that don't understand it's just an exemption from income tax. So most nonprofit organizations pay sales tax. And so if you're advising clients or if you're on the board, make sure that's clear, that they're understanding their responsibilities there. And the 990 is due by the 15th day of the 5th month. So usually if you're calendar year in, that's May 15th. And then you can apply for a 6-month extension if needed. The most important thing I think about the 990 is to know that it's available to public inspection. And I think a lot of organizations realize that if a donor or a funder asks for a copy of their 990, they have to give it to them. But I'm not sure everybody understands that it's just available out there. So this website, www.guidestar.org, if you haven't used it, get on it. It's great. All the 990s that the IRS receives go to guidestar.org. So you can pull up the 990 of any nonprofit you want to check out. So even if you're just sitting on the board and you want to compare some compensation information with other like organizations, you can get on there, and the top officers of the organization's compensation for the year will be listed on these Form 990s. So it's public information, and the 990, I'll go through a few of the different pages, but it really has great opportunities to tell your organization's story. So be sure you're doing that as you have the 990 completed for you. And a lot of times we as accountants are completing these 990s, but make sure you're reading them and the story is appropriate to what you want to tell, because we might not know that whole story if you're not communicating it to us. So just to go through a few of what I would say are the important pages of the 990. Page 1 is just a snapshot of the whole organization. So a lot of the information that's on page 1 comes from other pages of the 990. But again, if a donor was going to go look and just quickly look at page 1 would be where they'd go to find just a good summary of information. So it talks about the number of employees the organization has, how many volunteers the organization had during the year. It describes the organization's mission in a real brief 3 lines there. And then it gives key categories of revenue and expenses for the year, so they can see what are your main funding sources, where have you spent your money, what was your net for the year, and then finally total assets and total liabilities. Page 2 is one of the key pages where you can tell your story. And it asks you on this page to define your mission and talk about your top 3 programs and the accomplishments of those programs. So there's some organizations that keep that really brief. We do child care services, we do education. You know, I feel like that should be a place where you should really spend some time and tell them what you're doing. In Lincoln, the United Way there does an excellent job with their 990 and talks about all of the organizations that they grant funds to and what the outcomes those organizations had because of the grant money. So I think the add-on pages to this page 2, because you can add extra pages. I think it's like 15 pages long, but it is really clear as to who they benefited for the year. It does, yep. So if you're a June 30 year end, it'd be November 15th. So the 15th of the 5th month following your fiscal year end. Pages 4 and 5 of the 990 are just a checklist of questions. And from this checklist, it tells you if you need to fill out an extra schedule. So it's important just to kind of review these, make sure your answers are correct. Otherwise, you could be not completely filing your 990 if you're not getting attached schedules. Page 6 highlights the key aspects of governance and policy adoption. So it talks about how many board members you have, whether any of them are related or have transactions with the organization. But I really think the policy section is where you should probably place most of your attention on this page. And it talks about some different policies, or it asks about different policies that the organization might have. A whistleblower policy, document retention policy, conflict of interest policy is an important one. And if you're not answering yes to all those, you should probably think about adopting some policies, adopting those policies and then marking yes. So I think if it's important enough for the IRS to ask about, then it should be important enough for you to take up as a policy. So before I go on to unrelated business income, those were the main pages I wanted to highlight of the Form 990. Any questions so far? Great question. Yep. So the question was, do you think it's important to have the board review the Form 990? There is actually a question on the tax return that says, has your board been provided with a copy of the Form 990 before its filing? So it doesn't say they have to necessarily review it or approve it, but that they have to have seen it. So I think that, yes, it's important. I think that boards should review it. And at least, like I said, make sure it's telling the story that you want it to tell. and that you don't see any questions that should be answered yes that aren't. Any other questions? Ugh. Okay. Okay, do you want me to repeat those? Okay, so the first one was, what are your obligations for sales tax in relation to making online purchases where taxes aren't assessed? And I'd say your obligations are the same, unless you have a sales tax exemption, your obligations are the same than as if you're an individual or a for-profit. So use tax applies, and if you're not getting charged sales tax and should have been, you need to be remitting use tax. And you're subject to potentially being audited. I've had several large nonprofits lately that have been audited, and usually where they get hit is use tax. The other one I've seen a lot is if your organization sells any of its lists, mailing lists, that's subject to sales tax. A use tax is just like a sales tax, only the vendor isn't assessing it, so you have to remit it on your own. If you have an exemption from sales tax, then you're fine. You just need to provide your exemption to the vendor. The other question was, what are your obligations in relation to receiving contributions through something like Amazon Smile? And I don't know that there are any obligations. I don't know a lot about that. Other questions? It's kind of just like a contribution, yeah, and contributions aren't subject to any sales tax. So along the lines of the same discussion about nonprofits not being subject to income tax, I find a lot of times that organization or individuals, board members aren't very familiar with unrelated business income. And unrelated business income for a nonprofit would be subject to income tax at normal corporate rates. So unrelated business is defined as if you meet these three requirements, it's a trade or business that you're conducting, it's regularly carried on, and it's not substantially related to furthering the exempt purpose of the organization. And that number 3, I feel like people get hung up on a lot. And they say, well, you know, it's providing income that helps us to do our other services, our charitable programs. And that doesn't count. Has to be directly related to your mission. And so some common examples of unrelated business income that I often run into, the number one would be advertising income. So if your nonprofit has a newsletter or a directory, some sort of mailing like that, or an online periodical, if they're selling advertising in that, the advertising is income is subject to unrelated business income tax. And just like a for-profit business, you can offset that income with expenses that are allocated to that, but you have to go through that process and file the tax return even if you come to a net loss. The other kind of tricky one is rental income. And it's only rental income on debt-financed property. So if your nonprofit owns their building outright and decides to rent it out, that rental income isn't subject to unrelated business income tax. But if it's debt-financed property, it is. Non-member sales we run into every now and then. So I think the easiest example of this is to think of a country club. And a country club is exempt under the social activities rules, but it's about membership. So if you have non-members that are coming to eat at the restaurant or renting out the banquet hall of the country club, that non-member income is subject to unrelated business income. And then the last one's a little bit unique, but I think it's happening more and more. Income from providing administrative or management services. So I have a nonprofit that just really has a great accounting department, and so they have they've made some connections with other nonprofits in the community, and they provide them with accounting services. And so since that's a for-profit business or a trader business that isn't really furthering their exempt purpose, it's subject to unrelated business income tax. And I think this is something that the IRS will be looking more closely at in relation to nonprofits, potentially auditing more. Any questions on that? Generally, no, but what they would be looking for is whether your expenses are reasonable. So they allow you to allocate expenses if the expenditures are both benefiting your charitable purpose and this other income source. And so they'd be testing the reasonableness of that allocation. If the building has debt on it. Right. Yep. Yeah. The question was, is the only outcome that you have to pay tax on that? Is there any other consequence? Nonprofits think it's a big consequence to have to pay tax, but I'm trying to think. Well, mostly, yeah, it could affect your non-exempt status if your 90% of your activities is that business and only really 10% of your income is from charitable activities, then you've got an issue with your tax-exempt status. So the question is, gymnasium owned by the nonprofit rented back to the school who is a for-profit. Yeah, I mean, I think your taxable income would be the dollar. No, I think then you might be able to argue as part of your charitable purpose, potentially. Yeah. So the question was, would that be the same as if a church decides it wants to operate a daycare and rents the space to the daycare? So the question, he said he's going to further complicate it, but I think he made it easier. He said the church is a 501c3 and the LLC, or the daycare is an LLC, sole member is the church. So unless they needed that to be a for-profit LLC, I'd say that's probably a not-for-profit LLC or just a disregarded entity of the church. And then right, so if the church is a member, it would just fall under the church and you wouldn't have any issues with income. No, I don't think so because, like I said, the two would be consolidated together, so that income would be eliminated. So the church wouldn't have income and the daycare wouldn't have expense. It would be netted to zero. Okay. So here is my contact information. Happy to answer any questions you might have at any time, or if you're looking for more information on anything, just feel free to reach out to me. And if you have any other questions now, I think I have 3 minutes, so happy to take those. Okay, great. Well, thanks for having me. It's been a pleasure.
Thank you, Krystal. Our last presentation of the day is a panel, and two of our speakers will be returning, Terry Ferguson and Daniel Russell, and we are also bringing on board Stephanie Mattoon as our third panelist. It actually says we have 4, but that is that's incorrect. We have 3. Stephanie Mattoon is with Baird Home. She represents nonprofits and for-profit organizations at all stages of their life cycle with respect to corporate formation, mergers and acquisitions, corporate governance matters. She regularly assists new organizations in obtaining 501c3 or other tax-exempt status and advises existing public charities regarding compliance with federal tax law, including private benefit issues, unrelated business income tax, lobbying, and political activity restrictions, fiscal sponsorship arrangements, and public charity support determinations. And Stephanie is a University of Nebraska law alumna. So we welcome our 3 panelists.
Okay, very good. Well, we are each going to take just a little portion of this presentation. I'm going to start out talking about really a couple different areas of best and worst practices. I'm going to be discussing board engagement and oversight responsibilities, which will be a little bit expanding on some areas that other presenters have spoken about today, and talk about a couple of real-life examples where not following best practices led to some adverse consequences for the board and for the organization. I'll also briefly be discussing the decision-making of the board and some good and not so good practices in that area. And then I'll be handing it off to Terry, who's going to go through a real-life example of a board dealing with a poor-performing executive director, which is unfortunately something probably many folks in the room have had to deal with at some point. And then finally, Daniel is going to be speaking again from the Attorney General's perspective and probably giving some other real-life examples of where worst practices in board governance have led to Attorney General investigations. Okay, so again, the 2 topics I'm going to be talking about are engagement and decision-making. So first, I'm going to go through a few examples of good practices in the area of board engagement. And this is not an exhaustive list by any means. Daniel actually spoke to this issue earlier and I think did a really good job, so I'll probably kind of breeze through this. But first, obviously, we want our board members all to be informed, to be receiving regular communication. I think what Krystal showed us in the last presentation in terms of the dashboard is an excellent way to do this. one of the practices that we sometimes see boards engage in that is not so good on the information aspect is, not having communication in between board meetings. So you may have been a member of a board before where really all of the information that you're getting is at the board meeting, which is really not ideal, particularly if the board is not meeting very regularly. One thing I think Brett probably talked about earlier this morning is that, board members are not expected to be experts on every issue that the organization has to deal with. They are allowed to listen to independent experts, and it's a good idea for them to engage those experts on a regular basis on issues that they need consultation on. So again, board members should be prepared. This is, receiving advance notice of meetings, whether they're regular meetings or special meetings called for a particular purpose. Receiving documents well in advance of the board meeting. I'm sure many of you have been members of boards where you get financial statements the night before the board meeting and give you no time to review them. So making sure that board members are receiving information and actually reviewing that information and preparing for the board meeting. Board members also should be actively involved at the board meetings. So this means asking questions, engaging in an actual dialogue at the board meeting. I know a lot of board members, particularly when they're new to an organization, might feel uncomfortable, think that the questions that they're asking are dumb questions. Truthfully, it's the best thing you can do is ask those questions when you first join the board, because once you've been on the board for a couple years, then it may really be a dumb question that you're asking. So I encourage new board members, ask, hey, this may sound kind of stupid, but can you explain this line item on the financial statement to me? Or, is there a trend that we should be talking about here? So encouraging actual active discussion at the board meetings is important. Board members should also be planning for the future. So that's looking at, is the size of our board appropriate? Do we have the right composition of board members? Do we have the right terms? You'll see some nonprofit organizations where there are no term limits. Board members have been on the board for 20, 30 years. There's no new blood. That's not a good practice. It is important, though, to have some longevity and some, not a new board every year. So one good thing that I see a lot of nonprofits do is have staggered terms. So a few people are rolling off every year. You're constantly bringing in new blood, but you do have some people who know the history of the organization. That's important. It's also important to look at the skill set that is represented on the board and make sure that you have folks from different industries, different expertise areas. And again, very important that you have an independent board, meaning that the majority of the board members do not have a conflict of interest. That's important from the IRS's standpoint, and it's important to protect you all when making decisions as a board. The board should also be actively supervising and evaluating the staff. So I know this has been touched upon earlier, but remember that in the hierarchy of the nonprofit organization, the executive director reports up to the board. The board should be doing regular evaluations of the executive director to make sure that they are qualified for the job and actually performing their duties. The board should also be actively engaged in adopting bylaws and regularly reviewing those. So I see organizations frequently who adopted bylaws 25 years ago. They have no idea what they say, and they've never reviewed and updated them. So that the board should, or perhaps a committee of the board should be engaged in reviewing those bylaws, adopting policies. Krystal just mentioned, a few policies that are asked about specifically on the Form 990, and I'll touch on that here in a minute too. Those should be in place, but again, they should not be just set on a shelf and never looked at. They should be reviewed on a regular basis, updated, and most importantly, actually complied with. So again, this goes back to the IRS, what's on the Form 990 and what the IRS views in terms of good governance. Several years ago, they amended the Form 990 to implement this philosophy of good governance, and they have lots of things to say. None of these are mandatory rules, but they're very good idea for you to follow. And what they have to say about governance is that the board should be composed of people who are informed and active, as we just talked about, and that if the board tolerates a climate of secrecy or neglect, the charitable assets are more likely to be diverted to benefit the private interests of insiders at the expense of the public and charitable interests. So again, Krystal noted that on the 990 there are specific policies that the IRS asks you if you have in place, and you should answer yes. You should have those. There are good samples online that you can find of several of these, but you should tailor them definitely to your organization, because not every policy is appropriate for all of them. Okay, so here's some bad examples. This is kind of the opposite of what we just talked about. What are boards doing that really don't fall in best practices? Well, a lot of boards you will see have, they might refer to them as honorary board members. This might be somebody who maybe originally founded the organization 30 years ago, and you want to keep them on the letterhead, or someone who is a donor and you want them involved in the organization for reputational purposes, but they're not coming to board meetings, they're not actively involved. Those folks should not be board members. If they are board members, if they are directors, they owe fiduciary duties whether they're coming to the board meetings or not. So one thing a lot of organizations will do is they will set aside a group often called like an advisory board that is not the board of directors. They're not coming to all of the regular board meetings. They may be providing advice on a annual, maybe couple times a year, getting together to advise the organization, but they don't owe fiduciary duties. That's the most important thing. Education of new board members. So when you have a group of new folks joining the organization, if you don't do something special for them to kind of introduce them to the organization, what is your mission? What have you done in the past? This is how we present our financial statements. This is the dashboard that we use. It can take them a couple years just to get up to speed, just to get to the point where they feel comfortable asking a question at a board meeting or expressing a concern. And if you have a certain segment of your board that's just not engaged because they aren't educated and informed about what's going on, that's certainly not good for the organization. So you should be doing specific orientation and education of all new board members. Infrequent meetings. So the legal requirement is that the board needs to meet annually. Well, certainly you should be meeting much more than annually. And you can provide in your bylaws that a quorum is less than a majority. But you really shouldn't be doing that. You should if you have a majority of your board that's not showing up to board meetings regularly, you need to be looking at whether those folks should be board members and planning for the future and kind of getting rid of folks who are no longer active, maybe moving them over to an advisory board role and getting new blood on the board that's engaged and is going to actively participate. Rubber stamping staff recommendations. So this is a real issue in the nonprofit world, where maybe board meetings are the board members coming together, the executive director is reporting to them what's going on, the board's nodding their head, yes, oh great, you're executive director, you all knowing, you're doing such a great job, and just passes everything that's proposed by the staff without much critical review of it at all. And you don't have to admit if that's what's going on in your organizations, but that's what's happening at a lot of nonprofit board meetings. And it's true that nonprofit board members, they're volunteers. You have careers outside of it, but if you can't take it seriously and you can't prepare for the meetings and actually engage in a discussion of the issues at the meetings, then you probably shouldn't be serving on the board. So I mentioned this a little bit earlier, but the financial statements need to go out well in advance of the board meeting, and the board should have the opportunity to actually review those and review them critically. So as Krystal mentioned, not all board members have a lot of financial expertise, so it's okay to rely on those board members who do. If you have a CPA on the board, you've got a finance committee, you can reasonably rely on what those folks have to say about the financial statements, but every board member should be receiving them in advance and should be critically reviewing them and asking questions if you don't understand. So groupthink can be a real problem in the nonprofit world, and I talked earlier about new board members coming on feeling kind of like, no, this is how it's always done. Who am I to question it? Everybody else is on board with this method. There can be a lot of just kind of nodding around the table and hesitancy to raise a concern. And I'm going to give a couple of examples of how that can lead to kind of disastrous results. And not because the board members are bad people. They have great intentions, but that's really not fulfilling your fiduciary duty. So lack of diversity, and I'm not just talking about diversity in terms of gender and race, although those are good things to have at the table too, lots of different people from different backgrounds. But when you're adding new board members and thinking about the composition of your board, it shouldn't be just a bunch of friends or, you know, a bunch of people from the same industry, a bunch of family members. You really should be representing broad interests of the public because, again, you are serving the public as a 501c3 here. So one of the examples I'll talk about in a minute, you can just look down the board list and see there's a bunch of family members on this. And that looks a lot more like a private foundation than a public charity. So when you're thinking about the composition of your board, look at what are the gaps in skills. You know, do we have an attorney on the board? Many of you in the room are asked to join boards because they need a lawyer, and that's good. Do we have an accountant on the board? Somebody that has a marketing background? Do we have someone that is in fundraising? And then, of course, individuals that represent the mission of the organization. So if you're in early childhood education, having kind of experts in that field is obviously important. But everybody at the table should be a little bit different and representing different interests. Lack of oversight of staff, you know, I've kind of touched on that already, that the executive director is not the boss at the table. They really are reporting to the board. The board is responsible for evaluating them on a regular basis, making the hiring decision, and sometimes making the firing decision. And Terry's going to talk about that in a little bit here, I think. And then on the opposite end of the spectrum, I'm talking about lack of engagement, but there can be board members who are too engaged, who are micromanaging the staff involved on a daily basis. That is not the board's role either. You know, the board is up here at a high level overseeing and doing strategic planning. They are not showing up every day and, you know, doing evaluations of lower level staff members. That's not their role. Okay, so we talked about the good, we talked about some bad practices. So here's where it can get kind of ugly. Here's a couple of examples where organizations were not following best practices and how that led to some ugly results. So here, this is a community foundation in a town in California, small, medium-sized town, about 120,000 people, I think, or so. So much like the Omaha Community Foundation, you know, it's doing donor advice funds, supporting local charities. This particular organization had a long-term plan. They reported it every year in their 990, talked about it in their strategic planning. They wanted to build a facility that would house local charities, and they were well on their way. Last year, about this time, they had raised $1 million. And there was lots of local press about it. So, of course, you can see where I'm going with this. About a year ago, the board discovered some financial improprieties. So I thought this is a headline in the local paper last year that the district attorney was investigating possible financial improprieties at this community foundation involving the executive director. The board members did report it to the local authorities. So that's one good thing that they did. We talked about earlier, you know, if there is any indication of fraud or anything going on, you should be reporting that. So what happened after the DA investigated, the executive director pled guilty to stealing $55,000. What she was doing was writing checks to her mortgage company for her home mortgage. There was supposed to be 2 signatures on those checks, and she was forging the second signature. This was going on for 2 or 3 years. She'd been with the organization for 4 years at that point. So, of course, you know, what ends up happening, the nonprofit ended up suspending operations. This one roof project that they've been working on for literally a decade was completely canceled. Another organization kind of ended up taking it over, but this organization has been totally shut down at this point. So, you know, what could they have done differently? Well, we can see, because in the local paper, the board chair says, we weren't, you know, we had an opportunity to review the books and records of the organization, but what they came to realize is that they weren't asking the right questions or for the right documents. He now knows that they should have been looking and paying closer attention to the bank statements. None of the board members were looking at those. The only executive director was the only one that had access to those. Some other things that they might have done differently, I took a look at their 990 and all of those questions that we just talked about in the last presentation. You know, do you have a whistleblower policy in place? Do you have a compensation, certain measures on setting executive director compensation? Do all of your board members have a chance to review the 990 before it's filed? They answered no to all of those. And it was apparent that some of the board members were family members of this executive director. So while the directors weren't culpable in what she did, they didn't face any personal liability, they had to face the reputational harm that this organization went away while it was under their care, which is pretty terrible. So here's one that's even uglier than that, though, because this one led to personal liability for the directors. So this was a case in Pennsylvania. This was a nursing home where you can see here all of these defendants. These are members of the board of directors. So this is a nursing home, and I won't get into the details, but serious financial impropriety here. The executive director was violating state law. A couple of people died while under the care, and it was all based on financial mismanagement. Executive director went part-time, was still taking a full-time salary. Lots of things went wrong here, and they ended up filing bankruptcy. So this lawsuit was brought on behalf of the organization by unsecured creditors. There was a jury trial, 6-day trial. The jury deliberated for 3 days and came back with a $2.5 million verdict against these directors, plus punitive damages against 5 of them who were sort of the most responsible. This is the appellate court coming back and upholding that verdict. So these directors were individually liable. Now, this was an extreme case, but I think it's really good to remember that just because it's a nonprofit and just because there are some protections in the statute for you all, and you have directors and officers liability, does not mean that you're not going to be named in a lawsuit. And in extreme examples, these folks actually were personally liable for. Yes, sure. Yeah. What's that? Yeah. Well, I think that you would know if anybody had access to the bank account, right? They would see where those funds were going. Yeah, I don't think there's a foolproof way that you can catch everything. I think in this case, the board chair admitted they didn't have a culture where other staff members, maybe if they got wind that something was going on, it was a small organization. So, the fact that she was paying $50,000 out, somebody could have caught that, I think, if they were paying more attention. They didn't have a whistleblower policy. There wasn't a hotline for somebody that was under her to report if they suspected something was going on. But you're right. I mean, it's possible they might not have caught it even if they'd been doing everything perfectly. Yeah, so it was brought by the unsecured creditors, and the claims were breach of fiduciary duty under the theory of deepening insolvency. So basically, they didn't take action early enough, and then the financial situation got much worse because actually, I think what the court said basically was that they had actual knowledge. They had independent experts that came in and told them, you need to fire this executive director and replace her, and they just completely ignored it. Yeah, it was basically that they ultimately did vote to remove her, but it happened much later than where they should have taken action. So that was the theory. Yeah, and that if they'd taken action, a year or so earlier, the financial situation wouldn't have gotten as bad as it was. Yes, that was just the compensatory damages. There were $350,000 of punitive damages against 7 individuals. Two officers and 5 directors. Sure. So just a couple points here on, how the board makes decisions in terms of voting. So because I see this a lot, and I think there's a lot of misconceptions in the nonprofit world on these couple of these issues. So voting by proxy is something, I see this in bylaws all the time, that nonprofit directors can vote by proxy. I think a lot of times they're taking the language from the concept of proxy voting by shareholders of for-profit corporations. And I often tell them, again, you can't do this. I get pushback from them because it's a concept many people are so familiar with from being shareholders of for-profit corporations. What the statute says is that a member of a nonprofit corporation can vote by proxy. But usually we're not talking about members of the nonprofit corporation. We're talking about directors. So, Can directors vote by proxy? No, they cannot. So, individual directors, this is true of nonprofits and for-profits, owe fiduciary duties. You can't delegate those fiduciary duties to someone else. I have given this similar presentation to groups of directors around town, and at one of them I saw sort of this look of panic spread through the group that I was talking to, and it turned out that about half of them were there for their boss, who was the director, and sent them. So, I'm not going to tell who they are, and I didn't scold them or anything, but I said, given that what I was talking about that day was fiduciary duties and board governance, it would have been appropriate for their bosses to be there and listen to that. But if you can't go to a board meeting, you cannot send somebody on your behalf to vote for you or sign a proxy to vote on a matter for you. You need to be there, engaged in the discussion to exercise your fiduciary duties. Similar issue with voting by email. I joined a board at one point, and I'm not going to name which one it is, and literally a week after I joined it, I got an email from the executive director. I need you all to vote on this matter. Just respond to the email with a yes or no. And I was like, I'm sorry to be the bearer of bad news, but you can't actually do that. And they had a provision in their bylaws that allowed it. I think they had just found sample bylaws online that provided it. But just kind of as a refresher here, I think this might have been addressed earlier too, but there's two ways for a board to act. You can either have a board meeting, a physical meeting. It can be by telephone if everybody can hear themselves. There has to be, you have to have a quorum, and that's going to be dictated by what your bylaws say. You have to have notice of that meeting, especially if it's a particular action as outlined in the statute. Then you have to have 7 days written notice. So then the question always comes up, well, is an email sufficient for notice? That's actually kind of unclear. It's a good idea for you and your bylaws to say that you can provide email notice to the extent allowed under law, but it's not clear in the Nebraska Nonprofit Corporation Act that you can provide notice by email. So if it's a very important action, I would recommend doing an email and then maybe also sending a written notice by mail. If you can't have a meeting, or you don't want to have a meeting and you want to take action, then you need to have a written consent signed by each one of the directors. So this is where, some organizations might think that when they're getting responses by email that's sufficient, but unfortunately it's probably not. So the statute itself doesn't say what a signature means for purposes of getting unanimous consent. You might look at Nebraska's version of the Uniform Electronic Transactions Act, but it's not clear that actually applies to a nonprofit board decision. So what my recommendation to clients that push back hard on this is, if you need an immediate reaction from your board on something, feel free to send an email and get responses back. But if you want to take valid legal action, you need to have a meeting and call a vote. And you can do that by telephone as long as you follow the notice procedures. If you do mistakenly take action by email, you should ratify that at the next meeting. And the purpose there, of course, is if you don't have 100% of your board members signing a consent, you need to allow the opportunity for the board to discuss that. So the real problem with email voting is usually that you don't have 100% responses. And that is certainly not going to be valid action by the board. Yes. Yes, you mean in terms of you didn't give enough notice? Yeah, and even if you don't have everybody on the phone, if someone's not participating in the meeting and they didn't get enough notice, you need something signed by them saying, I waive the notice requirements. If they're participating in the meeting and they don't object to the lack of notice, then just their participation acts as a waiver. So you don't actually have to have everybody on the phone. You need a quorum, and anybody who doesn't show up or dial in, you need to get something signed by them waiving the notice requirement. Good question. Okay, so just a few best practices in terms of voting. If it's an important matter, my recommendation, even though you could get it by unanimous consent, I think you should vote in person. I think you should give everybody the opportunity to ask questions, present alternatives, obviously give as much advance notice as you can of the meeting, disclose any conflicts of interest that might be involved in the decision, have an actual thoughtful discussion, consider any alternatives to it. And then when you vote, make sure someone is taking good minutes. That does not mean writing down every word that every person said. In fact, that's usually a terrible idea. but showing that there was an actual discussion, perhaps noting how much time the meeting took, can show later on, if anybody questions whether there was a exercise of fiduciary duties, it's not whether you made a perfect decision, it's whether you followed a fair procedure and thoroughly discussed the matter. And then again, if you have to use email, my recommendation would be in your bylaws to include a Uniform Electronic Transactions Act provision, which again may not work, but at least you would say, to the extent possible, we're agreeing that we can act by or communicate, vote, give notice by electronic means. And then if you have to take that action by email, make sure you ratify it at a physical meeting. So with that, I'm going to present, well, first of all, are there any questions before we move on to Terry's discussion of the problematic executive director? We will take questions at the end as well.
Can I just remind the speakers to, if you get a question from the audience and I can't run across the room, can you repeat the question? We've got people on webcast that are sending us, we can't hear the question, so.
Okay, so here's the problem. You're the chair of a nonprofit board. It has a staff of 30 to 40 people, so it's a big organization. The board is huge too. There's over 50 members on it. They come from 7 states, so there's 7 from each state. There is an executive committee. It has 15 members. The organization has 4 senior managers who report to the executive director, who's been the executive director for almost 10 years. You live in Nebraska. The organization's offices are in Kansas City. There is a history of staff turnover that's never really been fully explained. The executive director has developed a close and long-term relationship with many of the board members because there are no term limits. So you get a phone call one day from one of the managers who reports to the executive director and outlines terrible management activities by the executive director. Micromanagement, belittling, playing people against each other, a toxic atmosphere in the office, and the four of them are going to resign if something isn't done about this. What do you do? Any thoughts? Well, you are the president of the board. Well, okay, there are 50 board members and living in 7 states. How would you keep that, everything that's happening in there, confidential? So that's the difficult question. So the question is, should you call a board meeting? What about an executive committee meeting? 15 people from a variety of states. If you've ever tried to engage in any personnel issues with a board, it's hard to keep people from blabbing about it. You can tell them they've got a duty not to say anything about what you're deliberating about if you're talking about a personnel issue, but many people don't pay any attention to that. And there's some serious liability issues if there's some disparagement of somebody by the board. So what about this strategy? You pick 4 board members, 2 of whom are former chairs, one of whom is the chair-elect, and one is a board member that served for a number of years that's an ex officio member. but has a voting ability, and you call them up and say, here's what happened. I got this phone call, this terrible situation. I can send you the notes of my conversation with this person, but this person wants to have a meeting, have a conversation. Well, let me step back a second. Instead of calling all those people together, suppose you do this. Suppose you ask that all 4 of these people get on a conference call with you and tell their stories. And you take notes. And they all corroborate what the first person said. And each has individual instances where they've been belittled, humiliated, micromanaged. There's a question.
Wait, hold it. I'm going to have you do it in the mic.
Not so much a question, but as a response, if you have that serious a personnel matter, you should select the 4 people on the overall board who have most experience in personnel and create a personnel subcommittee to investigate it. They can't interview 4 people at one time or take someone else's notes. They need to make an independent investigation inquiry to identify from each one separately what they identify the issues as in order to come up with a resolution to whatever this perceived problem is.
That's an interesting solution. The problem in this scenario was there's no personnel committee. There was sort of an ad hoc. Several of the people on the executive committee would get together with the executive director on a very, very informal basis to talk about how they were doing. So it wasn't as rigorous as has been outlined here. With the information that these 4 people conveyed over the phone, you make a phone call to and you assemble these other board members, and you send them copies of your notes, and you put the question to them. What do we do? What do we do with this information? What would you do with the information? What do you think this group should decide to do? Go to the full board, go to the executive committee, fire the executive director, go confront the executive director?
I guess what I would do is call up your fellow board members, those 2 past chairs, whatever, and get 4 of you together. But I would also call my outside legal counsel and have them conduct the investigation so it's protected by attorney-client privilege. And then you have the facts, whether those 4 people are just ganging up on the executive director or whether there are serious issues here that require termination. Once that investigation is done, that helps you make your decision.
Well, that's a really good advice. I wish I'd have followed that advice. So, that was what you're raising is the question that the other board members raised is, how do we know these people are not ganging up on this person? Because it came as a complete shock to all of us. None of us had any inkling that this problem existed, which is pretty typical of board members. They don't really know what's going on inside the staff, inside the office. You can get hints like turnover, but even when you do exit interviews, people don't want to burn bridges. They want to gracefully go away and not have any bad issues following them if they disparage the executive director. So what I said what about this solution? I'd like your thoughts on this. I knew there were 3 consultants that had worked closely with the executive director and all of the staff members, including these senior people, over the last few years. And they were regulars. They had been there, they were giving advice, and their advice was being used to make policy decisions. I propose that I call these 3 people and ask them for their evaluation of the management skills of the executive director, from their observation point. Any thoughts on that strategy? Yes.
Short question or short observation, but who hired the consultants? Are they truly independent? Did the board hire them, or were they hired by the executive director who they are now being called upon to judge, and it may affect this ongoing relationship?
All hired by the executive director.
In Houston, we have a problem.
Well, let me tell you what happened. All three of them corroborated what the four managers said, and then some. So now I'm armed with this information. I took detailed notes, and I call my group together on a conference call, and we review this information. What do you think? What do you think what do you think these other directors decided to do, or we decided to do? What would you think would be a good strategy from this point on? I think we've got two people here. There's two possible, two questions.
Yeah, well, two comments. One, if you're at that stage, I think you need to convene at least the entire executive committee, assuming the bylaws give the executive committee the authority to act in between board meetings. And I think at that point, the risk of blabbing is minor because somebody's going to have to be talking to the executive anyway.
Yeah.
The executive committee members hopefully can understand, if they're going to talk at all, be smart about what they're saying and not pointing fingers at the staff members that reported. But going back earlier, my question would be, what gives the chair and the other three board members any authority to do anything on their own without at least the full executive committee? Maybe the bylaws do, maybe the chair has authority, but do you have authority to hire outside counsel? Do you have authority to do anything as just 4 senior board members on your own?
Well, you're right. I didn't have any authority to do any of this, so I was in uncharted waters. My goal was and our goal became, how can we rehabilitate this person? And can we? She'd been the director for a number of years, and from all outside evaluation, the organization was doing a pretty good job. And that's what we decided to do. That we weren't going to take any precipitous action, but we were going to lay the information out in front of her and say, we want you to get some training in proving your management skills. And because the 4 people who had suggested this were terrified, we made it really clear that there would be no retaliation. And so I went down with another board member and we had these conversations. I'll tell you, one of the reasons I was reluctant to involve other people was that I was pretty sure that the personal relationships that have been developed over time would stand in the way of any action beyond trying to help her find her way as a manager. Let me say that the executive director, was in her late 40s, early 50s, and had only worked for this organization and one other in her entire career. So she was fixed in her ways. I did call somebody who was who trained executive directors, and that was his job, and he had a nationwide profession of that with some other people, and they would go in and talk to executive directors of for-profit corporations in trying to improve their skills and evaluate how they were doing as managers. When I ran this scenario by him, he said, you have only one choice. You need to terminate this person. You cannot rehabilitate. And I was, so of the 5 people that were in this select group, it's I guess I would call it a task force or a subcommittee, ad hoc committee, whatever you want to call it. I suggested that we needed to do something like that. I was completely overruled They wanted to give the person another chance. So that's what we did. So what do you think the result was? Got the training, all the good intentions, didn't work. So that person stayed, I left. So you don't always win these things. But I think I've been in other situations where a problem came up like this, and we took decisive action without any board. We did not ask the board to get involved. Three board members just said this has got to end, and there was fortunately the rest of the board supported us, but it was pretty clear to me we didn't have any choice but to make a decisive action. I think the logical thing to do would be to get, that's why you have an executive committee. Usually they're smaller, and if it was 4 or 5 people, it would be a workable situation. And usually they're senior people in the organization, and they're the ones that would have the savvy and the skills to make some decisions like that. Other organizations, we've involved the executive committee, which was a large committee. We couldn't keep a lid on what we were doing. It was just extremely frustrating. These are tricky situations, and I don't know if there's any really great answer to this. I mean, I've relived this episode a number of times, and I finally came to the conclusion that, I did what I did, and maybe it was the wrong way to do it, but we really did want this person to be, to fix her, get better skills and be more effective. It just didn't work. But you will run into situations where on a board where you will have an executive who's got problems. And the way you approach this is going to be different. Each time is different. Each problem is different. And the way you approach it has got to be carefully thought through. Hopefully less cumbersome than the one I came up with. But it's not, I've been on three boards where we had executive difficulties, and people had to leave. So it isn't a rarity. It's unfortunately, it happens.
Yeah, I was gonna ask for your comment on, as president of that board, what are your thoughts on just the basic leadership being put in a tough situation and making the decision because nobody else would? And sometimes that's what leadership comes down to, right? Is doing the thing that nobody else wants to do because it's what needs to be done. What are your thoughts on handling a situation like that from that approach?
Well, yeah, I think what you're saying, I'll illustrate it with a further discussion of this case I was laying out earlier. After a couple of years, after the training program and consultants and advisors and so forth, the same practices continued. So I addressed this question to the executive committee. I gave everybody the information that I had, and we decided we had to terminate. So we had a meeting, and somebody said, well, maybe we should try to bring another consultant in and do it. So they all backed off. So I couldn't get them to stick with the decision. And what I came to realize is lawyers, for better or worse, make decisions and then act on it. They review the facts, they look at the possible courses of action, and they say, this is what we're going to do. Or I'm going to recommend that you do this. Most people aren't like that. They don't like confrontations. They don't like nasty situations where people are going to challenge them for what they're doing. And so they took the easier way out.
One extra comment on that. A few years ago, was in a similar situation with a much smaller board and a staff member And I made the call, to do this. You're going to have a reprimand on your record. You're going to have this, that's going in your file. Remaining board and the executive committee jumped on my back about how I handled the situation. When it came time for me to discuss those matters with the officers, so to speak, the rest of my committee, I was the chairman of the committee, and that was that's how I got my board seat. But the rest of my committee came back behind me and said, no, you did exactly what we would have done. Is there any kind of, what are the risks of doing that in larger boards where you may or may not have the explicit authority to make those kinds of calls, but you do it nevertheless because it's something that has been put off and mishandled for such a long time that, by God, you're going to solve the problem right now.
Well, yeah, there is a risk. The risk that is that the board won't agree with you, and then you're in real trouble. The first one I did, the three people that were senior people on the board made the decision, and we terminated this person. And it was early in my nonprofit career, so I really didn't know what the hell I was doing. But I knew this person had to go. And I knew that if she stayed, our organization was going to suffer a lot of bad publicity. So we needed to take action. Knowing what I know now, I probably would have engaged more people in the process. Another one, we had the executive committee made the decision, but the decision wasn't to terminate. The decision was whether we would renew a contract. So the employment contract was expiring, agreement was expiring, and we had to decide, we had an opportunity then to say we're not going to continue the relationship. So it was a less fraught decision. But when you're actually talking about terminating somebody and you're asking a board to do it, you better get all your ducks in a row. And that's not easy.
Just want to, I guess, kind of a question or a comment on what your advice would be. But to me, this speaks to the need or the helpfulness of when it's possible to do a sort of anonymous evaluation of the ED from either the people they supervise. I'm on the board of one organization that's large enough that it only made sense to do the people that person directly supervised. Or if in a smaller organization, it could be the entire staff. Because I also had that experience of you can easily have no clue as a board member of the morale problem you have in an organization when you're just dealing with the executive director or even some of the management level people who are not necessarily comfortable coming and telling you that. So I'm just curious if you think that's also a good practice that boards should consider pushing either requiring or pushing their executive directors to consider.
Well, a really good executive director would welcome an evaluation like that. Somebody that's really nervous about, or self-conscious or insecure will not like that, and they'll push back. But it's a really great practice. Periodically have somebody come in from the outside and do an evaluation of the management of the organization and how the people in the organization feel about the management that they're under. And if people are willing to learn from that, and I think many executive directors would welcome any insights like that to make them better managers, it would be good.
It wouldn't have to be like an outside resource that you have to pay for to get that evaluation done. In my experience, and maybe this is wrong and not a great way to handle it, but I've been on boards where there's just a standard, come up with questions, it gets sent out, those people know it's going to be returned anonymously, the ED will not see it, so that it can kind of be done in a low cost. I mean, it's work for the volunteer board member who's coordinating it, and then you summarize it for the board, but it's possible to do without expending resources, I think.
Yeah, I think it only works, well, I would say that it probably works more effectively if it's a third party coming to do the evaluation. It makes it a lot less scary to the staff to open up because they know this is a professional that will keep it quiet.
Any other questions for the panel?
We didn't get to hear from you. So.
I just have a couple quick things. So first, just talking about this example Terry gave me, or Terry gave us. The first thing that was like nails on a chalkboard to me was the size of that board. That would be something I would really urge against. Also, kind of what we just talked about, having policies in place like whistleblower policies so that perhaps employees don't have to say, well, it's either me or her, make a choice, that they can kind of report these things as they happen are always helpful. And then the issue of consultants, right? So who is hiring the consultants? Is it the executive director or is it the board? And should the board be getting the results of the consultants? Because if the consultants are all saying, yeah, there's a problem here, but it's going to the executive director, then the executive director isn't telling the board, then the board is just in the dark, and why even hire the consultants in the first place? So I've had similar experiences where we've seen executive directors that are misusing money, that have significant ties to board members, either because board members are their personal friends or they've just been in place for a long time. Executive directors with gambling problems that are writing themselves checks from the company checkbook, but are also kind of insulated from any board pressure because they have friends on the board that just don't believe that they would ever do anything like this. So creating a culture where individuals can report to the board, can have an open dialogue with the board, I think is really important. And it's one of those things that I think when I was 21, if someone said, oh, like a culture in this workplace is really a thing, I kind of would have rolled my eyes and been like, no, I'm too cool to believe in corporate culture. But now that I've aged a little bit, I believe in it. It really is a thing that people that really does guide the way people act. Just a couple other quick notes I guess examples that to highlight from throughout the day today. We talked a little bit about whether or not to be a membership organization, whether or not your public benefit corporation should have members. So this comes up in sort of two different scenarios for our office. So the first is religious corporations and churches. So when they decide to have members, usually churches say, yeah, if you were baptized here, if you were confirmed here, then you're a member of the church. But then that gets tricky when you need quorums for votes to amend the Constitution or whatever. Same thing with sports organizations, right? If you sign up for a league, you're a member. But then how does that board make organizational decisions without all of these, soccer players or whatever, like getting together and voting? Similarly, if you decide to have members in your organization, then with that membership, they believe that, or, truly or not, that they should have some ability to influence the organization. So even if you're not a membership organization, if you decide not to have, legal members under the Nonprofit Act, if you are saying, give us $10 and you become a member, people like to think that they're members under the statute. And so they'll call our office and say, well, I'm a member of this organization, but I don't have access to whatever, which I should have access to under the statute. And then I look at the articles and I say, well, there aren't members of this organization. Maybe they exchanged, gave you socks or something when you donated $5 and said, thanks for becoming a member. But that isn't the way the statute works. Let's see, a couple other things. So we talked about rereading the Articles of Incorporation and bylaws every year. The thing that I would also add is to read the Nonprofit Corporation Act every year. I will say that is not popular because I have to force nonprofits to do it when they do bad things. And, just the fact that I have to force them to do that means it's difficult. But I promise you can get through it. My first day as a clerk at the Attorney General's office, they just handed it to me and said, read this until you understand it. So 2.5 years later, I graduated law school and told them that I kind of understood it. And then finally, board diversity. I think, we talked a lot about board diversity. What I would emphasize is it's not just gender diversity or cultural diversity, but also you want class diversity. So if you have a big board where all of the members of your board are titans of industry, we want those people to be engaged, but those people's view of what a reasonable salary is might be different from the people who your nonprofit is supposed to be serving, right? So what you want is a board that I guess is open, but also that is connected to the community and to the organizations, just kind of as a check on cognitive biases that they may have. So then the thing that I'll leave you all with is what our goal is at the Attorney General's office, and I think maybe what all of our goals are as lawyers is really this balancing act when it comes to nonprofits and charities between this public policy towards engagement and wanting people to be engaged in charitable activities. So we want to encourage charity as much as we can, versus also this really deep-seated need to be involved in, statutory need, and just legal need to be involved in the organization. And so, we try and I think about this balance every day to both try and encourage people to serve on boards and encourage people to get involved with charity, but also make sure people know that when they get involved with charity, when they serve on boards, when they become trustees, there are legal requirements and statutory requirements that they have to follow. And so, at the AG's office, what that takes is we try and separate the people who are misinformed but trying their hardest from the people who are malicious or ill-intentioned, and treat those people differently. So, as long as you're not ill-intentioned, feel free to come talk to the AG's office and we'll give you the best help that we can.
We have about 3 minutes. Lisa, do you have any questions on the computer? Any questions on the computer? Any other questions here?
One of the questions was about leadership, and then you're talking about having your hands tied in this situation, which sounds like it has come up several times where some personnel decisions need to be made and personnel need to be sent out the door. Can't you be proactive and in your bylaws or in your committee structure give the board president the authority to terminate, or give the personnel committee the authority to terminate, so you don't have to go to your 50-person board of directors? A mayor of a first, second-class city has the power under statutes to fire the city administrator. So why can't you be proactive and work that into your bylaws or your committee authority?
Well, I'll take a crack at that. I wouldn't agree with that as a strategy, because I think the board needs to make a decision to terminate an executive director. That's a big decision. It's probably the most important. Managing the who's the executive director is probably one of the biggest decisions, biggest responsibilities of a board. So I wouldn't want to divest the board of that critical function. When I look back on that story that I presented to you, I realized that what wasn't in place was the kind of procedure for people to raise those issues in the organization in a way that it would then trigger a series of evaluations, investigations by probably an outside party like a law firm to do the investigation, do the interviews, document the situation, and report back to the full board. That's a far more effective way than my ad hoc efforts to solve the problem. And, I would encourage you to look at your code of ethics or your bylaws or whatever where you talk about the rights of employees, board members, third parties. If they see misconduct or they see unethical behavior or violations of policy, that they can raise these issues with people who will then make sure that the board or a committee of the board learns of it, and that they have the authority to engage outside investigators to get to the bottom of it and make a recommendation to the board as to what to do.